You are here on a complaint that alleges that on or about July 20th, 2025, location in Pittsfield Township, specifically that being Washington Avenue, that you did at that time had possession of drug paraphernalia. You understand that, sir?
Right away, Judge Simpson puts the charge on the record: possession of drug paraphernalia, a misdemeanor allegation tied to a specific date and location. But notice the defendant's reaction. He is not just confused, he openly says he has no idea what this is about. That matters because this is the moment where the court is not deciding guilt yet. Judge Simpson is simply making sure the defendant understands what he is accused of before anything moves forward. And that is where courtroom procedure can look simple, but it is actually crucial. If the defendant does not understand the charge, the process cannot cleanly continue. The tension here is that the defendant sounds frustrated before the case even gets going, while the judge is trying to keep the hearing procedural. Viewers, what do you think? Genuine confusion or courtroom defensiveness kicking in early?
No, I don't, sir.
Pardon?
I have no idea what this is about with paraphernalia.
Okay, so have a complaint that alleges that on the date I just said, at that location, they're alleging that you were in possession of drug paraphernalia. I'm not asking, not saying whether or not you did it. You understand what you were charged with?
Yeah,
Do you understand what you were charged with?
I do today. Yeah, actually.
Okay.
I was being charged.
And that is a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs, and the court could order any substance abuse treatment. You understand that, sir?
Yes, yeah, sure.
You understand that?
Yeah,
Do you wish to be represented by an attorney?
absolutely.
At this point, this is a public defender case. And then somehow or another, they'll make the magical switch somehow or another.
For the time being, Assistant Public Defender Natalie and on behalf of Ms. Party, we would waive any further reading. My client stands mute and asks that a not guilty plea be entered, and we would ask for an adjourned pre-trial date.
Then have a waive formal reading standing mute. The court will enter a not guilty plea. Pre-trial in this matter will be adjourned. Did they say how fast they can make things happen? They can make it happen, brother.
They didn't say, Your Honor. I don't know.
All right. Why don't September 17th, will that work?
Works for me, Your Honor.
All right. I'll adjourn it out to September 17th, 2025. And as to your other matter, you want me to adjourn it to that same day?
Yes, please, Your Honor.
All right. So I'll adjourn this one to September 17th. Let me set bond conditions on me.
Now the hearing expands. This is no longer just about one paraphernalia charge. Judge Simpson is also looking at another matter connected to this defendant, and both sides are trying to line things up on the same future date. That is why the word adjourn matters here. It means the court is pushing the matter to another date instead of resolving it right now. The defense asks for that coordination, and the judge appears willing to set both cases together for September 17th. But that calm scheduling moment does not last long. The court is about to move from basic dates and pleas into bond conditions, testing, and possible violations. That shift is important because once bond compliance comes up, the tone changes. A simple status hearing can suddenly become a warning hearing, and that is exactly the kind of pivot that makes these courtroom moments explode.
Pardon? I don't know that that's a violation, is it? So we got a problem. They've listed it as a progress report, but on August 1st, did a 10 panel, or was supposed to do a 10 panel. He missed his test, stated he didn't have money to do it at the time. On August 4th, he did a 10 panel, Problem is, he came up positive for amphetamines. And he denied having any current prescriptions that would have shown that.
Can I speak of it?
Pardon?
I called them and I asked them what I should do if I should come in and test them first. And they told me, don't worry about it and call back the next day. And I called back and then I think the days are messed up. Like the moment I went and saw them, I went and tested.
What do you mean the days are messed up?
Because you said that from the 1st and the 4th. And it was only a day after that I'd spoken with them.
I'm indicating what this says. I wasn't there. Okay?
Yeah.
So I'm telling what it says. I am not so much concerned about the dates. I am more concerned about why you have amphetamines in your system.
I've been taking Adderall since I was 7 years old.
Did you tell them that you have a prescription? Do you have a prescription for
I
it?
lost my prescription, sir.
Pardon?
I lost my prescription. I had to change doctors.
This is the pressure point. The court is dealing with a missed test, then a later test that allegedly came back positive for amphetamines. The defendant says he has been taking the medication since childhood, but Judge Simpson immediately focuses on documentation. And that is the legal problem. Courts do not operate on "I've always taken it." They need proof, especially when bond conditions include drug testing. The defendant says he lost his prescription and has to change doctors, but from the court's perspective, that creates a gap. If there is no active prescription shown, the positive test becomes a serious issue. Judge Simpson is not debating the defendant's medical history. He is asking whether the defendant can prove lawful use right now. That distinction is everything. In court, explanations may help, but paperwork usually decides whether the explanation actually protects you.
Me and him got into it. It's, I even had the doctor's note from him saying that he can no longer be my, prescriber. Complicated story. Me and him got into it.
So you don't have a prescription?
No, I no longer have a primary care physician.
All right. Here's what I'm going to do. Sometime between now and the 17th, he needs to get back on and have his testing as he's supposed to have it. I'm not going to sit up here and argue with him tonight. Because I don't know, he knows what he's eating. I don't want to see those amphetamines unless he has a prescription in the system. Otherwise, I'm just going to make it real clear to you. I'll revoke your bond and you'll sit in jail until we get this thing done.
Okay.
Am I clear on that?
Yeah, I was just saying he's no longer prescribing me.
Am I clear?
Yes, sir.
I don't really need any more language from you.
Yes, Your Honor.
This bond in this case at this time will be set as $10,000 personal recognizance, a lower standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or illegal drug use, no possession of any weapons. I will sign a new community corrections order. I want him for testing. I want him tested once a week. All right. Thank you.
Thank you, Your Honor.
Assistant Public Defender Alexis serves on behalf of Mr. Thurman, who's approaching.
Olin Thurman.
Okay. Record should reflect prior to the system going down that we were having a bench conference. We concluded that bench conference. Fundamentally, the defendant was released to a particular address on a tether. That address is no longer available to him.
Now we move into a completely different defendant and a completely different type of bond issue. Judge Simpson explains that the defendant had been released to a specific address while on tether, but that address is no longer available. That may sound like a housing problem, but in court, housing can become a custody problem very quickly. If someone is released on bond with strict conditions, the court needs to know exactly where they're going, whether that location follows the order, and whether monitoring can work there. Here, the defense is trying to find a workable release plan, but the judge is already signaling concern because the proposed address may conflict with existing bond restrictions. This is where real life and court orders collide. Defendant may have nowhere else to go, but the judge still cannot ignore conditions that were put in place for safety and supervision.
He, in a nutshell, is has a place which he can be released to. However, his release to that place would be in violation of his current bond conditions.
Yes, Your Honor.
Even if there's somebody there. Even if there's somebody there.
Your Honor, and just to further, he doesn't have any other location to go. It is my understanding that there'll always be some other adult present at that location. Even when the mother's children does go to work, her parents come to watch the children while she's at work. So if the court's concerned, we would ask for that bond condition to be modified to say no children except his own children. Like Your Honor is aware, they are his children, and the mother is present in court and is willing to.
Right. I understand, but with reference to the primary case, his release, his contact with his own children of that other relationship is only supervised. Right. So what, and I get why you may be asking, but what you're in effect asking the court to do is then to release him in the presence of kids unsupervised.
Well, Your Honor, it's my understanding that there will always be someone else at the home while the children are present.
Yes, and I get that. I'm saying it's not a structured supervision under sort of some type of monitoring. I get what you're saying. And I'm uncomfortable doing that. Young man, you don't have any other place that you could stay?
No, sir.
Okay, because here's the problem. I'm gonna do this in a way to try to be fair, because he's come here, he said what his circumstance is. He's been released, can't go back to the place that he was. Has tried to find, in good faith, I think, alternative living arrangements. And so I'm not faulting him for that. I just think that releasing him to that would be in violation of his current bond conditions.
Judge Simpson is doing something important here. He separates blame from risk. He is basically saying, I understand the defendant tried to find housing, and I am not punishing him for that. But then comes the hard line. Releasing him to that proposed home would violate the existing bond conditions. That is a key courtroom distinction. Sympathy does not erase restrictions. A judge can recognize that someone made a good faith effort and still refuse the plan because the legal conditions do not allow it. This is also where the defense faces a tough reality. The defendant's lack of housing does not automatically make an unsafe or non-compliant address acceptable. What should matter more in a moment like this? The defendant's need for shelter or the court's duty to enforce bond conditions exactly as written? That is the dilemma Judge Simpson is weighing.
When I look at the bond conditions, the charges, I think that those bond conditions are appropriate. And so I'm not going to even modify or tweak those bond conditions in this case. I don't know enough to do that, first of all. But I also want to be fair to the defendant. So what I'm going to do, counsel, is I'm going to pass this to my 3 o'clock block.
Okay.
Give you an opportunity to try to find some other alternative in doing that. I think that's probably the best I'm going to do. I'm in effect, really what I'm doing is I'm resisting putting him back in. I'm going to give you a chance to kind of brainstorm, figure out something else before I'd have to come to that point. Okay.
Understood, Your Honor.
Okay. So we'll pass this to the 3 o'clock block. My last.
Assistant Public Defender Alexis Jefferson on behalf of Mr. Thurman.
All right. And this is a recall. Were we able to make any progress?
Your Honor, I believe I will be renewing my request to allow him to be tethered to his mother's children's house. So it is my understanding that allowing him to stay there would not be a violation of his current bond conditions because he is allowed to have supervised visitation with those children. And at this time, he will always be supervised.
Well, no. Because as I understand the bond conditions, he's not to have any contact with any children.
That no is the clearest line in this section. Judge Simpson shuts down the defense argument immediately because, as he understands the bond order, the defendant is not supposed to have contact with children. The defense is trying to frame the proposed living arrangement as supervised because another adult would allegedly always be present. But the judge is not accepting informal supervision as enough, and that matters because someone else will be there is not the same thing as structured, court-approved supervision. The court is looking for enforceability. Can the condition be monitored? Can it be guaranteed? Can community corrections confirm compliance? If the answer is uncertain, the judge is not going to gamble with a bond condition involving children. This is not just a technicality. It is the judge refusing to create a loophole inside an order that was designed to prevent contact.
Was the exception to that were the children that were the alleged victims in this case?
No,
Your Honor, if I may clarify, I don't know if this was entirely clear earlier. The alleged minors involved in this case are not actually Mr. Thurman's children. Those are the complaint witness children. He does not share those.
You're right. I misspoke. But he wasn't to have any contact with any children. The two other children, there was an exception for supervised visitation.
Correct. And Your Honor, my argument is that that is what he'd be partaking in by residing in that home. There would always be another individual present in that household. The children's mother takes the children to her parents' house during the day while she's at work. She picks up those kids, brings them home. Mr. Thurman would be obviously home by himself without the kids there. They would be at the parents' house, the grandparents' house, and then the kids would return with the mother. So the mother would always be present during those interactions.
On the record, we would be objecting to that, given the fact that we can't make sure that that happens all the time. And I would have great concerns of him being around children and living in a residence with the children, given the facts of the case. So we would be objecting for that reason.
And Your Honor, respectfully, even with the condition that he was allowed to have supervised visitation, there'd be no way to guarantee that that was taking place in the first place either. Your Honor, all this is being based off of right now is a 4-page police report. We did just receive some media discovery. I believe there's more to come based on a search warrant, but all of the information I have doesn't show that he's a danger to children at this time, especially his own children. Again, Your Honor, the children's mother is present in the court. She is willing to attest that she is perfectly okay with this arrangement, not feel unsafe leaving or having Mr. Thurman around their children.
Your Honor, I just have concerns given the facts of the case, even though it's much to the police, but we have a search warrant coming. But the facts of this case are that he put a camera in the bathroom that recorded the victim, her brother, and her children, and he sent those videos, including the children, to their father and other family members and other people, and the videos were of them using the restroom.
This is where the hearing turns heavy. The prosecutor begins laying out why the state is concerned, and the allegations become much more serious than a simple housing dispute. The court hears concerns involving surveillance, children, videos, and alleged physical confrontation. Now, the judge's reluctance makes more sense. The defense had been arguing practical supervision, adults present, mother willing, children's schedule managed. But the prosecution responds with the nature of the allegations themselves. And once those allegations involve children, privacy, and alleged distribution of images, the court's risk analysis becomes far stricter. Viewers, this is the moment where the entire argument changes. Is this about giving someone a place to stay, or about whether that place creates exactly the kind of risk the bond conditions were meant to prevent? Judge Simpson is clearly leaning toward caution.
I mean, I have concerns. The victim said that he admitted to her over text that he had more images, and when she confronted him about this, it became physical, and he was grabbing her necklace, breaking it, bit her arm, scratched her. And I mean, I have concerns given that this case does include surveilling children and sending those images to other people.
And Your Honor, without getting too much into the facts of the case, it's my understanding that Mr. Thurman filed his own police report a week prior to this police report being filed involving the complaining witness. He did provide a copy of that police report to me, and we do have that in our files. If Your Honor is unable to let him reside with at the home of his mom.
I passed this matter so you could find alternative arrangements. I've heard all of this.
And Your Honor, those are alternative.
The way that it's going to work. Either he finds alternative arrangements or he's going back into custody.
And Your Honor, those other alternative arrangements, the only thing they were able to work out is putting Mr. Thurman up into a motel. They do have a location picked out, and they have confirmed that there is rooms available at that location.
Then I'm not going to have a problem with that either. Is that what he's going to do?
If Your Honor is not letting him.
I am not. I think I made my position real clear when we were at the bench. And I think my face, if not tone, is making it very clear as to my interpretation of this order. And no matter how many times someone goes to say it, the crux of the order is he is not to be around children. There are two exceptions. I'm not creating other exceptions.
And Your Honor, we would not object to the motel.
Your Honor, then I believe at that time that is what Mr. Thurman will be proceeding with.
We'll need that. He'll need to submit that address of the motel within 24 hours to the court and to community corrections. Then he can do that. And you're requesting an adjournment of these proceedings?
Yes, Your Honor, I'd be asking for the closest possible date.
The what?
The closest possible date that Your Honor can accommodate.
August 19th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. And is an email to your staff sufficient for providing the address? Thank you.
This is the final practical resolution. Judge Simpson refuses to create another exception allowing the defendant to live around children, but he does not immediately send him back into custody once the motel option is presented. The ruling is clear. The defendant may proceed with the motel arrangement, and Judge Simpson requires the motel address to be submitted within 24 hours to the court and community corrections. The case is then continued, with the next closest date set as August 19, 2025. The takeaway is simple. Judge Simpson was willing to be fair, but not willing to weaken the core bond condition. The court balanced housing, supervision, risk, and the allegations, and the strongest line remained no unauthorized contact with children. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.